Chapter 7. Who may be complainants. SS 107. Parties complainant. The rights of the two great classes, existing and subsequent, into which creditors are necessarily divided, having been considered, the discussion would not be complete without noticing in detail the cases in which complainants in various capacities are allowed to prosecute the class of litigations under consideration. The principle must be kept constantly in view that fraudulent conveyances can be assailed only by those who have been injured, and are voidable only in favor of parties occupying the positions of creditors or subsequent purchasers. The creditor who first institutes a suit in chancery to avoid a fraudulent conveyance is entitled to relief, without regard to other creditors standing in the same right, who have not made themselves joint parties with him, or taken any proceedings. The creditors spoken of as entitled to discover equitable assets or null covenants transfers are the creditors of the grantor or donor making the fraudulent conveyance. That if fraud upon the public was the design of the transfer is not a sufficient ground for avoiding it. A fraudulent purpose is harmless if unattended with any wrongful effect. Again, the fraudulent intent, as we shall show, must be connected with the transaction assailed, and not relate merely to some entirely independent act. But it is not necessary that any particular creditor should be mentioned by name. It is well observed by Chancellor Kent in Brown v. Ricketts that the question of parties is frequently perplexing and difficult to reduce to rule. The remark, as will be manifest, is peculiarly appropriate to the different actions and proceedings affecting fraudulent alienations. We may further state that suits by creditors form no exception to the rule which requires that all the parties in interest who are in S shall be brought into the case. SS 108. Joinder of complainants. Let us first notice the authorities relating to the joinder of complainants in the various forms of actions instituted by creditors. Parties who are creditors by several judgments may, as a general rule, join as complainants in an action to reach property fraudulently alienated by a debtor. In Robbins v. Sand Creek Turnpike Co., the court quoted the following language approvingly: several persons having a common interest arising out of the same transaction or subject of litigation, though their interests be separate, may join in one suit for equitable relief, provided their interests be not adverse or conflicting. And several judgment creditors holding different judgments may unite in filing a creditor's bill to reach the equitable interests and chooses an action of the debtor, or to obtain the aid of the court to enforce their liens at law. And in Powell v. Spalding, the doctrine is laid down to the effect that where there is unity in interest as to the object to be obtained by the bill, the parties seeking redress in chancery may join in the same complaint and maintain their action together. In Brinkerhoff v. Brown, Chancellor Kent ruled that different creditors might unite in one bill, the object of which was to set aside a fraudulent conveyance of their common debtor. It was so held also in McDermott v. Strong, Edmeston v. Litt, Conroe v. Port Henry Iron Co., Wall v. Fairley, and Mebane v. Layton, and where a defendant in two separate bills, brought by different judgment creditors to reach the same land, files one answer to both bills, it seems that he thereby virtually consolidates the suits, and they may be heard together as one cause, or as two causes under one style, without entering any specific order of consolidation. In one case, a sheriff and the judgment creditor under whose execution a levy had been made were allowed to join in a creditor's bill. Each, it was said, had an interest in preventing a multiplicity of suits and in closing the matter in a single controversy. Their interests were in harmony and in no respect conflicting, and hence of such character as entitled them to unite in the suit. There is, however, no obligation upon judgment creditors to join. Creditors by judgment and by decree may unite in one suit, but judgment creditors and simple contract creditors cannot join. Where one party is a creditor by judgment and another by decree, both having acquired liens upon the property of their debtor which entitle them to similar relief against an act of the defendant, which is a common injury, they may join in a bill. The general theory upon which creditors are permitted to unite as complainants is that they are seeking payment of their judgments out of a common fund, viz., the property of the debtor. His fraudulent conduct with reference to his assets affects them all, and is the subject matter of investigation. A receiver is often appointed to reach and take possession of equitable interests, or property fraudulently alienated, and as he can act equally well for the different creditors, the expense, delay, and confusion incident to conducting different suits are avoided. A judgment creditor of a firm who is also a judgment creditor of one of the members of the firm may sue on both judgments to overturn an assignment. Obviously, hostile claimants cannot join in any form of action, and a bill is demurrable where it appears that one of the complainants has no standing in court, or antagonistic causes of action are set forth, or the relief for which the complainants respectively pray in regard to a portion of the property sought to be reached involves totally distinct questions requiring different evidence and leading to different decrees. SS 109. Suing on behalf of others. Mr. Pomeroy says, one creditor may sue on behalf of all the other creditors in an action to enforce the terms of an assignment and trust for the benefit of creditors, to obtain an accounting and settlement from the assignee, and other like relief, also in an action to set aside such an assignment on the ground that it is illegal and void. And also one judgment creditor may sue on behalf of all other similar creditors in an action to reach the equitable assets, and to set aside the fraudulent transfers of the debtor. In all these classes of cases, the creditors have a common interest in the questions to be determined by the controversy. The complainant may sue alone or with other judgment creditors. It is remarked by Nelson, J., and Myers v. Finn that the practice of permitting judgment creditors to come in and make themselves parties to the bill and thereby obtain the benefit, assuming at the same time their portion of the costs and expenses of the litigation, is well settled, but this intention must be manifested by suitable averments in the bill. And if, after a finding of the court annulling a fraudulent preference, other creditors seek to come in as co-complainants, they may be allowed to do so, but their demands will be postponed in favor of the original complainant. Stockholders may sue in the right of the corporation where the latter refuses to proceed, but where there is unreasonable delay in bringing the suit, the cause of action may be defeated by the application of the doctrine of equitable estoppel. Where one incurs expense in rescuing property belonging to many, a court of equity has power unquestionably to direct that the expenses so incurred shall be paid from the common fund. S. Psalm 110. In others, it is a mistake to suppose that the statute of Elizabeth only avoids deeds and conveyances coming within its exact provisions as to creditors. The statute is much broader in its operation. It enacts that every conveyance made to the end purpose and intent to delay, hinder, or defraud creditors and others of their just and lawful actions, etc., shall be void. It extends not only to creditors, but to all others who have cause of action or suit, or any penalty or forfeiture, and, as we shall see, embraces claims for slander, trespass, and other torts. The claimant may not come within a sharply defined meaning of the word creditor, but he may maintain his standing in the equity of creditors. So in Fagley, why? Fagley, the court say, the statute seems to design to embrace others than those who are strictly and technically creditors, and if, under such a comprehensive clause as creditors and others, a wife who has been made the victim of her husband's fraud is not to be included, we are at a loss to ascertain to whom else it was designed to relate. Then the principle that a voluntary post-nuptial settlement made by a person indebted is prima facie fraudulent, as to creditors, applies as well in behalf of the representatives of a deceased partner as of general creditors, and a partner who liquidates firm judgment stands in the position of the creditor with regard to fraudulent alienations of his copartner. SS 111. Surety. Sureties on an appeal bond may be subrogated to the rights of the judgment creditor to bring a creditor's action to set aside fraudulent deeds, even though the principal informed the sureties of the fraud before they became bound. Sureties may enforce their rights in the creditor's name if their interests require it. For a surety who pays a debt for his principal is entitled to be put in the place of the creditor, and to all the means which the creditor possessed to enforce payment against the principal debtor. It may be here recalled that a surety is a creditor of the principal obligor, and of his co-sureties from the time the obligation is entered into, and that a conveyance by a surety for inadequate consideration to defeat a contemplated liability for contribution to a co-surety will be set aside. A person who pays a debt as security for a firm becomes a creditor of the firm and is not entitled to any greater rights than simple contract creditors. SS 112. Executors and administrators. Ordinarily, an executor or administrator will not be allowed to impeach the fraudulent conveyance of his testator or intestate. Like the heirs, he is bound by the acts of the deceased. As a party to a fraudulent conveyance cannot allege its illegality, with a view to its avoidance, so neither can his heirs nor representatives. coming in as volunteers and standing, as it were, in his shoes. This language is employed in Rhode Island if the deceased has conveyed his estates away in fraud of his creditors. The creditors who have been defrauded are the proper parties to prosecute the remedy. Statutory changes supported by the tendency of the courts to prevent the confusion incident to splitting up the administration of estates between creditors and personal representatives have led to the general establishment of the practice of permitting and imposing the duty upon executors and administrators to sue for property fraudulently alienated by the deceased in his lifetime. Thus, in New York, executors and administrators, who could not formally effectually impeach the conveyances of the deceased on the ground of fraud against creditors, are now enabled to do so by statute. This new remedy, however, is not exclusive. In that state, if the personal representative is in collusion with the fraudulent vendee, the creditors may bring an action against the personal representative and vendee to have the covenants transfer set aside and the property applied as assets. And in Wisconsin, the creditor may in a proper case compel the executor or administrator to bring the action, or bring it himself. In Pennsylvania, it is said that the administrator's intervention would not seem to be necessary if the creditors prefer to proceed for themselves. But it seems in such a case, in New York, that the creditor must ordinarily first exhaust his legal remedies and reduce his claim to judgment. And in Wisconsin, the insufficiency of the estate to pay debts must first be ascertained by the county court. This prerequisite, as already shown, is not universally conceded to be essential. The Supreme Court of the United States asserts, in a comparatively recent case, that the authorities are abundant and well settled, that a creditor of a deceased person has a right to go into a court of equity for the discovery of assets, and to secure the payment of the debt, and the creditor, when there, would not be turned back to a court of law to establish his debt, the court being in rightful possession of the cause for a discovery and account, will proceed to a final decree upon all the merits. So debts which are made by statute a lien upon lands of a deceased debtor will furnish a creditor at large, the correctness of whose claim is acknowledged by the executor, is standing in court to file a creditor's bill to set aside conveyances alleged to have been made by the testator in fraud of creditors. The creditor's bill in Kennedy v. Creswell was filed against an executor in Devices and alleged that the complainant held the testator's notes for $12,000 and recited that the personal assets were insufficient to meet the debts, and that the executor was paying some of the claims in full and leaving others unsatisfied. The creditors prayed for an accounting of the personal estate, a discovery of the real estate, and an application of all the property to the payment of the debts. A plea was interposed setting forth that the executor had assets sufficient to pay the complainant and all other creditors. A replication was filed and proofs taken, which sustained the allegations of the bill and demonstrated the falsity of the plea. The court decided that the complainant was entitled to a decree pro confesso, and the defendant could not claim the right to answer after interposing a false plea, that the admission of the executor that he had assets could be taken against him for the purpose of charging him with a liability, but it could not serve him as evidence to prove the truth of his plea. SS 113. The personal representative may render himself individually liable to creditors for a failure to recover property fraudulently alienated by the testator or intestate, and he should include such property in the inventory, unless, of course, he has no knowledge of it. The personal representative, as he stands for creditors when so acting, can only attack fraudulent transfers in cases where the estate is insolvent, and with a view to recover a sum sufficient to satisfy the creditors. The complaint should allege that the action is instituted for the benefit of creditors. The legislation clothing personal representatives with the power to appeal to the courts to annul covenants alienations made by the deceased is highly salutary in practice. The concurrent right of the creditor to seek redress is also of the utmost importance, for the personal representative is usually selected by, or is a near relative of, the deceased, and may, in some cases, be prompted by motives of friendship or self-interest to shield the parties who have depleted the estate, and, in some instances, is himself the fraudulent alienee. Where the personal representatives sue, a multiplicity of suits is prevented in cases where the creditors are numerous, and the necessity of a judgment or execution is avoided, features important to the body of creditors. SS 114. Assignee in bankruptcy. An assignee in bankruptcy, under the late Bankrupt Act, represented the whole body of creditors, and could in their behalf impeach as fraudulent a conveyance of property by the bankrupt, whenever the creditors might, by any process, acquire the right to contest its validity. This rule is of quite general application. It is said, however, in the New York Court of Appeals, that if the assignee should refuse or neglect to sue for and reclaim property fraudulently transferred, it is abundantly established that the creditors may commence an action to reach the property, making the assignee, the debtor, and his transferee's parties defendant, and, in such an action, the property will be administered directly for the benefit of the creditors. It is believed, however, that it is impossible to reconcile this doctrine with the decisions of the United States Supreme Court. For, according to the latter court, if the assignee in whom the right is vested neglected to prosecute during the 2 years allowed by the Act, the right to attack the fraudulent transfer would be absolutely gone. The assignee appointed under the Act became vested with the title to the bankrupt's assets by an assignment from the court, into whose custody the estate was, in theory of law, entrusted. Even a claim in favor of the bankrupt against a foreign government passed to the assignee. The assignee is regarded merely as a trustee for creditors. When his accounts are passed and he is discharged, the property not disposed of reverts to the debtor by operation of law without reassignment. SS 115. General Assignee. It is a general rule of law that a person cannot, by any voluntary act of his own, transfer to another a right which he does not himself possess. A fraudulent transfer of property by a debtor, made with intent to defeat creditors, is, as we shall presently show, conclusive upon the debtor so that he cannot himself reclaim it. No logical theory can be easily framed upon which it can be said that an assignment, wholly voluntary on the debtor's part, vests in his assignee the right to attack fraudulent transfers. Consequently, it has been decided that the right to impeach or set aside a mortgage which is fraudulent, and void as against the creditors of the mortgager, did not pass to an assignee of the mortgager by a voluntary general assignment and trust for the benefit of creditors, subsequently executed and unaffected by any statute in force at the time. Still, there are many states in which an assignment in insolvency or a voluntary assignment is held to vest in the assignee the right to avoid a conveyance made in fraud of creditors, and in some states the power is statutory. Such an assignee may also set aside a mortgage or other conveyance which is void as to creditors, for want of registration or other defects, and in some cases it is held that the assignee may affirm such fraudulent conveyance, and thereby estop creditors from impeaching it. In New York, creditors cannot assail a fraudulent alienation so long as there is a valid assignment in force. The right of attack is vested by statute in the assignee. SS 116. Receivers. Under the practice in New York and in some of the other states, the receiver of a debtor may impeach fraudulent transfers. The appointment confers upon him the right to set aside all transfers made by the debtor to defraud his creditors, which the creditors themselves could have avoided. In Bostwick v. Mink, it was decided that the right of a receiver representing creditors and acting in their behalf was no greater than that of the creditors themselves, that the legal and equitable right of the creditors was limited to securing a judgment setting aside transfers as fraudulent only in so far as might be necessary to satisfy debts, and that, when this was accomplished, the receiver's duties, and consequently his powers, and his right to act further in behalf of the creditors, ceased as to the property that had been conveyed by the debtor. The receiver stands in the place of the judgment creditor. In Alney v. Tanner, after a careful examination of the authorities, the conclusion is reached that a receiver appointed in supplementary proceedings cannot be held to be vested by virtue of his appointment with the title to property fraudulently conveyed by the judgment debtor. The court will refuse to put him summarily in possession of the property covetously alienated. It will not authorize him to meddle with it, and will refuse to protect him in so doing. The receiver may, as we have seen, assail the covenant's transfer by an action. Grover, J., said in Bostwick v. Mink, he acquires no right to the property by succession to the rights of the debtor, no rights of property other than those of the debtor are acquired. He does not acquire the legal title to such property by his appointment. That is confined to property then owned by the debtor, and the fraudulent transferee of property acquires a good title thereto as against the debtor, in all other persons, except the creditors of the transfer. The only right of the receiver is, therefore, as trustee of the creditors. The latter have the right to set aside the transfer and to recover the property from the fraudulent holder. And the receiver is, by law, invested with all the rights of all the creditors represented by him in this respect. In New Jersey, a receiver, appointed by virtue of the statute providing a method for discovering the concealed property of a judgment debtor, can, in his official character, exhibit a bill in chancery to annul sales of such property or encumbrances upon it, on the ground that such sales or encumbrances are in fraud of creditors. In the case first cited, Parker v. Browning is quoted with approval. In the latter case, in speaking of the course to be taken when property, which is claimed by a receiver appointed by the chancellor, is in the hands of a third party who claims the right to retain it, Chancellor Walworth says the receiver must either proceed by suit in the ordinary way to try his right to it, or the complainant should make such third person a party to the suit and apply to have the receivership extended to the property in his hands. A sequestrator or receiver of personal property and rents appointed in an action may, under the direction of the court, test the fraudulent alienation of property, though this question is much confused in New York. SS 117. Receivers of corporations. Receivers of insolvent corporations, when suing for portions of the capital, represent creditors and not the corporation, and are clothed with other rights than those which the corporation possessed. It is a fundamental principle, upon which the American cases at least proceed, that the capital of a corporation, especially after insolvency, is a trust fund for the benefit of creditors. It is foreign to our purpose to enter into the wide field of corporation law relative to insolvency, but the principles of these cases are valuable as showing that the representative, receiver, or liquidator of a corporation is, like an administrator, assignee, or receiver of a debtor vested with the status of a creditor, where a statute creates a cause of action in favor of creditors who are within certain prescribed conditions. A receiver cannot enforce it. It may be observed here that the power of the comptroller of the currency to wind up the affairs of a national bank in certain contingencies does not exclude the authority of a competent tribunal to appoint a receiver in other cases. SS 118. Foreign receivers. In Booth v. Clark, the court say, a receiver is appointed under a creditor's bill for one or more creditors, as the case may be, for their benefit, to the exclusion of all other creditors of the debtor, if there be any such, whether appointed, as this receiver was, under the statute of New York, or under the rules and practice of chancery, as they may be, his official relations to the court are the same. A statute appointment neither enlarges nor diminishes the limitation upon his action. His responsibilities are unaltered. Under either kind of appointment, he has at most only a passive capacity in the most important part of what it may be necessary for him to do, until it has been called by the direction of the court into ability to act. He has no extraterritorial power of official action, none which the court appointing him can confer with authority to enable him to go into a foreign jurisdiction to take possession of the debtor's property, none which can give him, upon the principle of comity, a privilege to sue in a foreign court or in other jurisdiction, as the judgment creditor himself might have done, where his debtor may be amenable to the tribunal which the creditor may seek. So in Brigham v. Ludington, which was a bill filed in the Southern District of New York by a receiver appointed on a judgment creditor's bill in the Eastern District of Wisconsin, the suit was dismissed, to the suggestion of counsel that, by the statutes of Wisconsin, receivers appointed on creditors' bills are vested with full title and have full authority to maintain suits, which the Circuit Court of the United States for the Southern District of New York ought to recognize. Mr. Justice Ruff said, this receiver was appointed under and by virtue of the general power of courts of equity, and with such effect only as is due to the order of the court making the appointment. He was not appointed under or by virtue of any statute. The statutes of the state of Wisconsin cannot enlarge or alter the effect of an order or decree of the Circuit Court of the United States, nor enlarge or modify the jurisdiction of that court or its efficiency. A doctrine is growing up in favor of recognizing foreign receivers by comity. SS 119. Creditors of corporations. Creditors of an indebted corporation may have the aid of a court of equity against the corporation and its debtors to compel the collection of what is due and the payment of its debts. In Graham v. Railroad Co. will be found an important discussion by the learned Mr. Justice Bradley of the effect of a voluntary alienation of property by a corporation as affecting subsequent creditors. In this case, counsel urged that the property of a corporation was a trust fund for creditors, and that this meant all creditors becoming such during the life of the corporation. The court, however, could discover no reason why the disposal by a corporation of any portion of its assets should be questioned by subsequent creditors of the corporation, any more than a like disposal by an individual of his property should be so attacked. This would seem to put corporations and individuals upon the same footing as to voluntary alienations, as regards a certain class of creditors, but the distinction must not be overlooked that the corporation itself may recover the property, where the voluntary or fraudulent transfer was effected by faithless or corrupt officials. Creditors of a corporation who have exhausted their remedy at law may proceed in equity to compel a stockholder to pay up a balance due upon a subscription. So judgment creditors of a corporation may follow corporate assets into the hands of stockholders amongst whom it was divided before the debts of the association were paid. SS 120. Sheriff. When process comes to his hands, the sheriff may undoubtedly attach any property which has been transferred by an alleged fraudulent assignment, and hold it subject to the decision of the court upon the question of fraud. In such a case, the sheriff must defend the seizure in behalf of the creditors, and show that the assignment was fraudulent as to them. As to creditors, the title to such property does not pass if the assignment is fraudulent, but it remains liable to seizure to satisfy their debt. The case is different when the assigned property has been sold by the vendee and its identity destroyed. The proceeds cannot be attached or levied upon by the sheriff as the debtor's property. Merely setting aside the assignment would not vest the title to such proceeds in the debtor. The only remedy of the creditor in such a case is to institute a creditor's suit, and fasten a trust upon such proceeds for the benefit of creditors, which necessarily confirms the legal title of the assignees to the assigned property, instead of annulling it, as would be the case if the sheriff had seized the assigned property instead of the proceeds. SS 121. Heirs, widow. The heir of a grantor cannot impeach his ancestor's deed on the ground that it was made in fraud of creditors, for he can claim no right which the ancestor was estopped from setting up. The statutes avoiding fraudulent transfers are, as we have shown, available only to the person or persons who might be delayed, hindered, or defrauded. The heir at law is not a proper party to enforce an alleged trust in personal property in favor of an intestate. It may be here observed, though possibly extraneous to our general theme, that one of several heirs may maintain a suit to set aside a conveyance procured from the ancestor by means of the fraud and undue influence of the grantee, and that the other heirs may testify in the suit as to personal transactions with the deceased. A widow cannot sue in chancery to have her husband's land sold, her dower right satisfied, and the balance applied to creditors, nor can a widow who has knowingly joined in a fraudulent deed maintain a bill to set the transfer aside. SS 122. Husband and wife. The relationship of husband and wife assumes considerable prominence in our subject and will be specially treated. We may here observe that a husband compelled to pay ante-nuptial debts of his wife becomes her creditor, and as such is entitled to set aside fraudulent conveyances made by her in contemplation of marriage. So also a wife may attack conveyances executed by her husband with intent to defeat her right of dower which was about to attach. It seems to be well settled that, pending a divorce suit, a wife asserting a just claim for alimony is within the meaning of statutes prohibiting fraudulent conveyances to be deemed a creditor. SS 123. Tort creditor. A right to damages arising from a tort is within the protection of the statute 13 Eliz. C5, and a conveyance made to defeat such right will be set aside, if the intent was in part to evade fines upon criminal prosecution, and also to evade the payment of any judgment which might thereafter be obtained in a civil action. The conveyance would be wholly fraudulent. It cannot be upheld in part and avoided in part. Hence it has been held that an action at law, although in maleficio, is within the meaning of the statute which protects creditors and others against conveyances made to defraud them of their just and lawful actions, suits, debts, accounts, damages, penalties, forfeitures, and demands. The judgment creditor in an action of trespass has a judgment for such a cause of action as justifies his attacking in some form any conveyance made by the defendant pending the suit as being fraudulent against him. and should not be prevented by injunction from putting himself into such a position that he may have the question of the bona fides of the grantee's purchase tested in a court of law and before a jury through an action of ejectment. SS 124. Overseer of the poor. In New York, an overseer of the poor has no standing in court before judgment to impeach the voluntary deed of the father of a lunatic child, upon the theory that the conveyance was executed with the intention of imposing the burden of supporting the son upon the town. It seems to be clear that an overseer cannot secure equitable relief setting aside a fraudulent transfer if he is not a creditor by judgment or by simple contract, and no liability has been established in his favor, by adjudication or otherwise, against the alleged fraudulent grantor. SS 125. Creditors having liens. A conveyance is not considered fraudulent as to a creditor whose debt is secured by judgment or other lien upon the land transferred. The grantee necessarily takes subject to the lien, and the creditor may pursue the land in the same manner as if it had been conveyed to one who had purchased in good faith for a full consideration. He may follow the land irrespective of changes in the title, whether honest or dishonest. A judicial sale upon his lien vests in the purchaser the title which the debtor had when the lien attached, and of course divests the title of the debtor's grantee. The creditor, therefore, stands in no need of aid from a court of equity to revoke the debtor's transfer. This question was considered in Armington v. Rao, in which Hawk's appeal was cited with approval, and the court further said the debtor conveys subject to the lien. He has a right, upon such condition, to sell or give away his land, and if he does so fraudulently, the grantee's title is good against all the world, except creditors and persons intended to be hindered, delayed, or defrauded. A prior lien creditor is not person. The such conveyance, whether bona fide or fraudulent as respects creditors who have no liens, is no obstruction or hindrance to the enforcement of payment of the prior lien. SS 126. Purchaser removing encumbrances. A purchaser at execution sale takes the creditor's right to avoid all fraudulent conveyances and encumbrances, and may file a bill in equity for that purpose. A creditor who has obtained judgment and issued execution may seize and sell the property of his debtor, and try the title of anyone who sets up a prior lien or encumbrance affected with usury. So a conveyance of property gives to the grantee or assignee the right to file a bill to annul a previous invalid conveyance made by the same grantor, and a judgment creditor may compel the cancellation of prior judgments against the debtor upon the ground that they have been paid. SS 127. Creditors opposing will. As a general rule, no creditor has the right to oppose the probate of a will. The right of contest is limited to the heirs at law and next of kin. It may be here observed that, in Fisher v. Bassett, it is said that no debtor of an estate could be allowed to plead nunquam administrator and bar of an action for the recovery of a debt due to the estate. The greatest confusion and mischief would ensue if such were the law, for then, wherever delay was desired, every debtor would deny the jurisdiction and arrest the recovery of a just debt by embarrassing inquiries as to the decedent's domicile or the place of his death.